A very good morning to everyone watching us today. This is the ODPP Café. Welcome. Thank you very much for joining us today. My name is Anita Onuko. I'll be your host. Remember, this is a show brought to you by the Office of the Director of Public Prosecution, and it's a show that is meant to inform you and educate you and more sensitize you on matters of criminal justice system. Feel free to let us know where you're watching from. You can comment and tell us, you can ask us any question you have, at least with regards to this topic today. I have a team of experts who I will introduce a bit later, and there are other experts waiting to respond to your questions on social media. We are on Twitter at ODPP_KE. We are on Facebook, as you can see, and also on YouTube at the Office of Director of Public Prosecution. Please subscribe, follow us, share this video, share this the tweets so that we can have a wider conversation on the topic today. Engage with us. We are really here to engage with you and to educate you and to clarify things that you may not be able to understand about the criminal justice system. So I'm going to introduce my panel today, my power panel, and I'm going to start with Madam Dorcas. Please introduce yourself and tell us a bit about yourself. Of course, we know you, but yeah.
I'm Dorcas Oduor, a senior counsel, and I'm the Secretary of Public Prosecutions. And I took part in the development of the decision to charge guidelines. This is the second time. The first time when we reviewed the 2015 policy, and when we came up with the new one, and I'm amongst the people who's been tasked to operationalize the new decision to charge guidelines. And as one of the managers in the ODPP's office, it is my responsibility for purposes of succession to make sure that the people we leave behind operate and apply the decision to charge properly. Thank you.
Thank you so much. Wamaida?
Morning, Anita. My name is Wamaida Kimani. I work with International Justice Mission. I lead their function on policy, partnership, and advocacy. We have been partners with the Office of the Director of Public Prosecutions since about 2012, as they were establishing as an independent office, and we have worked alongside them as they worked on the statute, then their initial policy, prosecutorial policy, and subsequently as they developed these key tools on streamlining the decision to charge.
Okay, karibu sana. Yeah.
I think Anita, I'm Steve Ogola.
If you are not on social, then you don't know Steve.
I'm a trial advocate,
Okay.
litigation lawyer,
All right.
and the managing partner at Sarong and Stevens Advocates. Okay. But permit me to recognize, and I was listening to you and the powerful introduction you've given us. We must recognize and celebrate the aggressive public information sharing, campaign that ODPP is doing. It's really transforming lives. For majority of Kenyans coming into contact for the first time with the criminal justice system, having some basic information or understanding on arrest and pretrial detention, plea taking and plea bargaining, bail, bond, and surety is very, very critical. It builds their confidence, because we say, if you don't know, then you enter the criminal justice system based on rumors and guess what? And an ill-equipped client, because those are your clients, probably is not going to have an effective defense strategy if they don't have defense lawyers. So I think we must commend. We are always quick to fault public institutions, but very slow to recognize and celebrate the small wins. I don't think within the East African community there is an equivalent of the DPP elsewhere that is doing this. I think we are trailblazing and continue with the good work. I really, really learn a lot, and I hope that Kenyans that listen to this also learn a lot.
Yes.
Good job.
We do. Yeah. I'm also learning. I say, join me on the journey of empowerment. I always say that. Yes. Tomika, karibu. Welcome.
Thank you so much. Good morning, Anita.
Good morning.
And the rest of the panelists. My name is Tomika Patterson, and I'm a federal prosecutor from the United States, working with the U.S. Department of Justice. And I'm stationed here at U.S. Embassy, Nairobi. We've had the honor and pleasure of working with the ODPP over a period of years, and got the pleasure of helping the ODPP see other countries and how they develop decision to charge practices and the processes for intaking a case. So had the honor of leading a study tour to the United States and to Scotland with the DPP and the SPP and other members of the Decision to Charge Implementation Committee. And we continue to support their efforts during the implementation process.
Thank you so much for coming. I keep saying on this show that American series, crime series, are really pointers. Steve, you must agree. They need someone who has actually conceived the idea of how their case got to go because of what they watched on How to Get Away with Murder, for example. So you bring pointers. Karibu Mule.
Yeah, thank you very much. I'm Vic Samude. I'm Acting Deputy Director of Public Prosecutions. I'm in charge of Columbia Affairs and Prosecution Services. This entails overseeing the performance and the responsibilities of all the prosecution counsel throughout the country. With regards to the decision to charge guidelines, I'm a member of the implementation committee. This means that I am responsible, together with my other committee members, with rolling out the decision to charge guidelines to all the prosecution counsel throughout the country. We are also sensitizing them through online forum on how the decision to charge guidelines should be utilized.
Yeah, I was just about to ask you how COVID has affected the rollout.
We are
and
doing
you just answered
virtually,
virtually.
Through the country, but immediately the pandemic
yeah.
is
Once you get over
we get over, we'll do it now physically.
Okay.
Yeah.
Thank you so much, everyone, for coming. We'll get into the discussion, and of course, we start with Madam. First of all, what is the decision to charge? Am I right in saying that it is the most important decision that a prosecutor has to make?
Yes. The decision to charge, amongst other decisions, is the most important decision that a prosecutor can make. But will you allow me to just give a background of this decision to charge document?
Yeah.
Now, we all know that the Constitution of Kenya 2010 birthed a new paradigm in prosecutorial services in the country. For the first time, it created an independent Office of the Director of Public Prosecutions with powers to direct the Inspector General to investigate any matter. The institution that has been created by Article 157 of the Constitution has been given sole state powers to exercise, has been given solely the power to exercise state powers of prosecution in all courts and in all offences. Meaning that within the government or within the state, the only institution that can exercise prosecutorial powers is the Office of the Director of Public Prosecution. And allow me also to mention that in exercising the state powers of prosecution, the Constitution provides that the Director of Public Prosecutions may initiate criminal proceedings. And that is important because it is the justification for discretion in the decision to charge, which means prosecution in Kenya is not mandatory. It will depend. That is why the word may under Article 157 is very, very important. Secondly, the Constitution provides that in exercising those powers, the Director of Public Prosecutions must have regard to the public interest, avoid abuse of the process of court, and also to enhance and protect human rights. That is also very important because when we'll be looking at the decision to charge, how we operate the decision to charge, you'll hear about two tests, the evidential test and the public interest test. It is because of this other provision of taking into account the public interest and the interest of the administration of justice and to avoid the abuse of the court process that the idea of the public interest comes in and discretion of the prosecutor comes in.
Yeah, let me just take you back to the point where you are part of the AG's office and now you're independent.
Yes. Before the 2010 Constitution, the Office of the Director of Public Prosecutions was a department within the Office of the Attorney General.
Yes.
It was one, I think, of the 6 departments. And at that time, we were only 94 prosecutors and we only had about 12 field officers. And during that time, the Deputy Director of Public Prosecutions then, because the Attorney General was the Director of Public Prosecutions, so the head of the Department of Prosecutions was the Deputy Director of Prosecutions. And the Deputy Director of Prosecutions, since there was no capacity, we were very few. So we could only afford to prosecute in the High Court and in the Court of Appeal, or very, very serious cases in the lower court. And those cases made up only 5% of all the cases in the country. Therefore, the police prosecuted 95% of the cases in the lower court. And because we did not have a policy on the decision to charge, the police investigated and decided which cases that they took to court, and they also decided what to do with them. So the Director of Public Prosecutions was not aware or was not in charge of all the cases that were getting into the system at that time.
So I think also it explains why we only knew the AG then. Amos Wako was very famous then.
Yes.
I think there's a generation that just knew Amos Wako.
Because he was the director of public prosecution.
So he was involved in all cases.
Yes.
Yes. And again, just from a local, from a Mwananchi perspective, a lot of the times we watched Viwaja Mahakamani, and our understanding of a prosecutor was a policeman. So even right now, I believe people don't know that this thing has changed.
Because most cases start in the lower courts.
Yes.
And in those lower courts, the person who was prosecuting was the police officer. So the police officer could investigate, could prosecute, could withdraw. The Attorney General then, or the Director of Public Prosecutions would only come in if it was a serious matter or it was on appeal. And that time, Kenyans were not very litigious the way they are now.
No.
So very few cases were getting the limelight.
Yeah.
It was mostly murder cases, robbery with violence. We didn't have
A
all
bit
these
of
other cases.
corruption, yeah.
And that will explain why we had to professionalize prosecution services, because crimes have evolved. You know, initially when the police were the ones investigating and prosecuting, it was backed by our colonialists.
Yes.
Most laws were legislated because of the Africans, and it was mostly physical offenses. And these were offenses that you could see. There was nothing like economic crimes. The very, very, very complex cases that
were still
defined
very,
by law.
very honest.
Yes, and you find that the physical offenses that were being prosecuted then, they were almost like moral offenses that everybody was aware of,
Yeah.
but things have changed.
Yeah. I'm just wondering, Mule, did you practice law then? How was it? Under the ages?
No, I was in private practice, but we used to meet, of course, police prosecutors in court.
Yeah.
They would come and prepare. Some of the cases you end up in court whereby maybe somebody has done a decision and say, let the court decide.
Yeah.
You have a helpless case, the essential ingredients are not proved. There's no case here of that. This could even be a civil case,
Yeah.
which could not have ended in court. Or,
So cases just went
went to
free. Yeah, okay. So, Madam, just continue with the historical background. Yeah.
So now, after the new constitution around 2013, we realized that we had to take charge of prosecution in the country. And that is how the Director of Public Prosecutions then, he was the Chief Public Prosecutor, before we appointed him the Director of Public Prosecution, Mr. Koriako Tobiko, decided to professionalize prosecution services by removing police prosecutors and employing professionals as prosecutors.
Yeah.
So we took over prosecution from the police, and they moved out of the courts. But we realized, even though we took over prosecutions, we were still being fed by the police. So they were the ones who were making the decision to charge, because they were bringing the cases and then we prosecute. So we realized that we also had to take over the charging decision so that we could be responsible for the quality of cases that were coming to court, and we would be sure that we were doing justice to the public by prosecuting only cases that were prosecutable. So you asked me that the decision to charge is the most important decision that a prosecutor can make. Yes, it is. And it is because the work of a prosecutor entails decision-making every day. Our work is a decision-making decision. You make the decision to charge, you choose the offenses, you make the decision about who you will call, you make the decision about what you're going to disclose, you make the decision to oppose or not to oppose bail, you make the decision to divert, you make the decision to enter into a plea bargain agreement. So decision making is a constant element that entails the work of a prosecutor. Yeah.
Oh, okay. So I also read somewhere that it is the one function, maybe not, again, I stand corrected, that speaks to the independence of this office.
Yes.
The decision to charge.
Yes, because the independence of the prosecutorial services is functional in the functions that we exercise. So when you're making the decision to charge, you are not supposed to be influenced by any other external factors, be it political, be it race, be it gender, be it tribe.
But you have seen people even online saying that you are not independent enough. I mean, how else do you prove you're independent?
And that is the reason why the decision to charge policy is very important, because it requires us to document and to publicize why we make a decision.
Okay.
And that is why you realize that when people make noise about the DPP, why he made this decision, when we disclose the evidence that we have, and you realize that we had sufficient evidence with a reasonable prospect of conviction, they don't talk about it because we base our decision on the evidence that we have.
Okay.
You see, the police will rely on a probable cause in order to arrest. But the fact that you rely on a probable cause to arrest,
What is a probable cause? People can't help. What's a probable cause?
See, for example, I'll come and tell the police that Mr. Mule, I gave Mr. Mule 10,000 shillings to buy for me a camera, but he did not buy, and therefore he defrauded me. There is a probable cause because I can show that I gave Mule money he has not returned. But now, as a prosecutor, I will have to ask myself, does it meet the threshold of theft or fraud? Because Mule will come up and say, but we had agreed that I will only buy the camera when the cameras are available in the market. So there is a reason for you to be arrested, but is there a reason for you to be prosecuted? There are other intermediary factors.
Okay.
And I will explain to you when I will be telling you the gap between the national prosecution policy that we had before and to date.
All right.
So then,
so maybe just a minute. So Steve, have you practiced law when this was under the AGs? How was it?
I did, but I've observed what is notable is this. I think if you look at the decision to charge as we know it today, one of the single most benefit, and I agree with senior counsel, that the decision to charge is one of the single most important decisions a prosecution counsel can ever make, because it can impact on other rights like the right to life, freedom, liberty, property, and so on and so forth. But there is a more important, urgent question that these guidelines have now resolved: the removal of opaqueness and arbitrariness.
You haven't spoken English yet. Opaqueness and arbitrary. We are speaking
okay, I'm trying to speak in English.
Yeah.
but the point is this, not losing the audience. People doubted. Remember, there was a time when there were genuine and legitimate concern whether the DPP undertook his mandate to persecute or to prosecute.
Oh, yes.
Because, there was no known formula.
Received as evidence.
Yes.
And this was actually part of where the greatest conflict came between prosecutors and investigators. When a prosecutor says they're not satisfied, they give back the file to the investigator.
Yeah.
But the feedback, for instance, we got during the study was investigators are saying, the file is being rejected, but I'm not being told why.
2015. And we also had and still have a general prosecution guideline. And these documents existed and nobody questioned them during that time.
I guess it's just about public sensitization again.
Yes,
and
expand on the application of prosecutorial powers based on principle of access to justice, human rights, open justice, accountability, and transparency. But they were found to be having a gap. The main gap that led us to relook at the decision to charge was the fact that the evidential test was not well expounded in the 2015 public prosecution policy. And I will give you a quick example because we are short of time. I only just wanted to explain the evidential test so that my colleagues can also come in. And for the public, the evidential test is the test that you undertake to make sure that you have sufficient evidence with a reasonable prospect of conviction. I will give you an example. We have talked about the two tests. The evidential test will talk about the public interest test. In the evidential test, it is in the statute. It is either common law or it is in the statute what the offense is. So the offense is defined and the punishment is defined and the ingredients of that offense are also defined. Now, for example, in the evidential test, the prosecutor will have to make sure, like in any other criminal case, that there is the actus reus and there is the mens rea. That means
You have
that
lost me.
I'm going to explain. Now, I'm going to explain.
Yeah. Okay.
In all the facts that the police will collect from the field, the prosecutor will have to satisfy herself or himself that the person who is the suspect committed the offense, in that he did the act. And in looking at the actor's rules, there are, for example, 4 elements you look at. You have done the act. If it is murder,
Yeah.
you pulled the trigger, or you used a panga, or you whatever, that
Yeah.
you did the act. But other than that, the circumstances under which you did the act. That is actor's rules, because it is something that can be seen. It is external. Actor's rules is external. You did the act, you catch the person with a panga. The circumstances, like it is in this house, it is in a hotel, you did this, and then the resultant
Yeah.
a consequence of that act. For example, if it is murder, it is the death of the person. And then we also look at the circumstances. The circumstances. So you look at whether you did the act, the circumstances, and then the results. It does not mean that if you did not do the act, you cannot be held accountable, and we will explain. So that is one element of the evidential test. The other one is the intention. Because in a criminal case, there is the actor's rules and the mens rea. So the actor's rules is the external one, what people can see.
Okay.
You have done it in these circumstances, and this is the result. Now, the mens rea is the intention. And sometimes you see they say intentionally, fraudulently. We want to look at your mind using external factors. So actors use as external, mens rea is internal. Now, it is the one of the prosecutors that when you come with the actors rules, you've already proved the actors rules, they have to go back and look at the element. Did you intend? And that is why we say prosecution is not scientific. And that is why you need to make the decision to charge, because you can have the external element, but you have to make sure, did the person have an intention to commit the crime? Other than strict liability offenses, for example, not paying taxes, where you cannot say that I did not intend. Where the law, it is the conduct that has been criminalized. For example, driving without a driving license, strict liability, because you did not have it. You cannot say that I did not intend. So you can see it is not a very easy test to apply, and we must guide the young prosecutors.
Yes.
For example, in a murder case, you can have all the external ones, the actors' rules, you pulled the trigger, I know the circumstances, I know the results. The law requires me to subject the suspect to a medical test to make sure that
Mental assessment. Yeah.
Because if I fail that test, then irrespective of what I have here, the person will not be responsible.
Yeah.
And those are the intricacies that the prosecutor must deal with.
Yeah.
Yes.
Okay, I just ask you, Amaida, you were involved in this process, I believe, from the onset. What informed IJM to get involved in this process?
So IJM is a global organization, and in every country that we have a presence, we'll take one form of violence that appears in the community, and then we bring in lawyers and other criminal justice actors, and we support people through the criminal justice system.
Okay.
As we are representing people, we are assessing where the outflow is in the criminal justice system. If you look at it as a pipeline, what's the thing that's causing the leak? To make sure that if an injustice comes into the justice system, it delivers on justice. And from then, our experiences representing people over a period of time, we partnered with the Office of the Director of Public Prosecution, because as Madam Senior Counsel is saying, they were taking a big leap. In 2013, 2014, as they were moving into the independent office, they moved from 94 prosecutors and did a mass hire in a single stroke. They were the largest law firm in this country. They hired 540 prosecutors.
Wow.
So from a team that had seasoned experience at the High Court, who were senior, who were lawyers, and then you add in another group, and then you're sending them out to the field and saying, take over these files and take over prosecution.
How did that work? I mean, there were these seasoned cops who were prosecutors, and then one day you tell them, hand over to a youngling the file, they should continue. How did this work?
As you would expect, there were complexities to that transition, and it's institutional complexities, it is criminal justice, and even the practice of criminal justice complexities.
And even development of crimes.
Yes, there was police prosecutors who were vastly experienced.
Yes.
People who could run a prosecution,
from end to end.
From end to end without much thought.
Yeah.
And then we are hiring lawyers, and there isn't a training school for prosecutors. So you're hiring legal counsel and then appointing them as prosecution counsel and saying, go out in the field. It then became a very necessary thing, even to support their relationship with their investigators and police officers, to create a consistent way in which this decision to charge is being made. And so around that 2014 time, as they headed out to the field, the DPP's office suggested a study on how the decision to charge is being made. And so in 2015, 2016, we went around 8 stations across the country with the team from ODPP. These stations were picked for different reasons. The kind of cases they were having, busy court stations, some transit stations, for instance, VOI, so you have local crime as it appears in that area. Then you have the ones who are passing by, so you have road traffic, you have highway crime. And so we picked various cases for various court stations for various reasons. Meru, because it had a high number of originating murder trials at the High Court. So also assessing how this office supports prosecutors who are still in the High Court. When we assessed the making of the decision to charge and how it was done, actually, because it's a justice study, so unlike a health study where you check were ARVs distributed, were shots taken, this was a review of files. So we called for registers from these stations, and the registers, because the registers are manual books, we had to count the number of cases because we're looking for cases from November 2014 to, I believe, September 2015, which is when the new prosecutors had gone out into the field. So we counted all the cases that had originated during that period, assessed how many we wanted to review, went to those individual stations, requested police officers, because prosecutors had no files, requested police officers to produce those files at the prosecution offices, opened every single one and assessed whether there was sufficient evidence in each one of those cases. It was truly an adventure. It was difficult, but what it did, and I think that was what was critical for the prosecution office, even as they moved to then streamline how the decision to charge is made, it made the office aware of what is the experience of this prosecutor you have sent out to the field. Because again, you remember the bulk of the prosecutors who were present in the office had been high court prosecutors. They were not lower court. So they were not moving at that level and experiencing those kind of cases. Out of the files we reviewed, so the registers had about 10,000 files, we reviewed a bit more than 600. Out of the files that we reviewed, 100, all those files had 109 offenses. And so as she was talking about murder, theft, robbery, 109. But 12 offenses were repeated 68% of the time.
Wow.
Now, why that's important is because it tells you what your routine offenses are. So that you ease the work of a prosecutor, even as you think through what guidelines are you giving them for their work. Let me make it easier for you around the cases that are going to be routine. So we had law and order offenses that were routine, idle and disorderly, drunk and disorderly,
loitering,
crossing a road, and you have offenses that are routine. Then you have the ones which are tied to property. There was stock theft, there was stealing, there was theft by servant, there's robbery, violence, burglary. Those appeared repeatedly. And then the ones against people, assault, causing grievous harm, causing bodily harm, grievous harm, and defilement. Those were the 12 offenses that repeated themselves the most time. The other things that came out from the study, the relationship between the prosecutors and the investigators, the dynamic around what I have in my file as a prosecutor, what the investigator has as their file. My access as a prosecutor to the file in order to prepare, because I cannot be receiving the file this morning and headed to court the next day. And then even just a streamlining of operations. If then you're aware that this number of offenses repeat themselves the bulk of the time, is the workflow for people to handle these routine offenses. And routine, I say, with reservation, because these are critical life decisions for people. So is what it means for a prosecutor to handle this, so that you spend enough time preparing them for the cases that they will not have much experience.
That showed up during All for Justice when the DPP just came in, and
even when we went around
20 prisons, you can talk to that.
Let me talk about that. So what All for Justice was, is the DPP and the team from the prosecution office, Madam SPP, went around prisons. So, of course, the irony being the prosecutor decided why you should be here. And now they came taking longer. And so they came and asked them, why are you here? Why have you taken so long? And it also spoke to the limitations on bail and bond. It spoke to, if you have such many petty offenses. Again, for like the majority of cases, 34% of them were ending up with a guilty plea. So if you have so many people who are willing to say, yes, I did
I'm
it,
guilty.
why go through the system as opposed to encourage them to bargain out at the start?
Yeah.
So that we ease the
Make it
system
restorative.
to deal with
Yeah.
emergent crimes that are starting to weigh down
The
the
system.
economy,
Yeah.
they are weighing down our communities, they are weighing out everything around us. Because the more severe crimes require more attention, require more specialization.
And I'd just like Tomika to speak to that a bit. Transnational crimes, I mean, what are they, first of all? Why should I care that they exist as a common citizen?
Well, transnational crimes are ones that cross borders. They are crimes like narcotics trafficking, human trafficking, wildlife trafficking, corruption, money laundering. So they might occur in Kenya, but the ramifications, the consequences reach far beyond that. For example, money laundering often happens because you take and commit a crime in Kenya and the proceeds are going
Taken elsewhere.
to somewhere else, whether it's the United States or the UK or anywhere in the world. So the impact isn't just in a single country, it crosses boundaries. And I think that's the reason why the decision to charge is so critically important, because it doesn't just impact Kenyan citizens, but it impacts both foreign nationals who are living here, working here, want to invest here, and also other individuals and businesses and other countries across the world. That Mr. Mule is talking about. You not only have to ensure
Not guesswork.
it's not guesswork. It isn't. And conviction and sustain that conviction on appeal.
And Tomika, you're right, because I was going to request Anita that Steve, as a private lawyer or as a practitioner, one of the things that the decision to charge has done is that we document the evidence we rely on when you're making the decision to charge. And then the requirement by law and the insistence by the DPP that before we make the decision to charge, suspects must be given an opportunity to write a statement under inquiry or a charge and cautionary statement. And further, the fact that now we are required to disclose. How the disclosure of evidence, how does that work?
And I even have a rider to that. Now that everything is tabled, everything is on the table, has it changed how you do the importance of that? Yeah.
The information is really fantastic in the sense that I just don't think defense lawyers really understand this, but it's very important that defense lawyers and even the public understand this, so that the interplay, how they have the connection between the prosecution counsel making the decision and the input of the suspect in that decision. Because you may not think that the suspect, sorry.
Did he lose all that?
Oh, sorry.
Sorry, do that again, yes. But at least our question was hard. Yeah.
As an accountability tool, the decision to charge necessarily means that once the prosecution counsel receives the inquiry and the investigation file, he reviews the evidence of record. And he has to satisfy himself that this evidence discloses a prima facie case.
What is a prima facie case?
A case that is led to convict or protection.
Okay.
But I think the more important element or aspect in the decision to charge is the input of the suspect, and more often than not, the public have not really updated their mindset about how they view the DPP. And the defense lawyers sometimes sabotage the interest, maybe inadvertently, the interest of the suspect. Because you see, the DPP must satisfy himself that this file, the investigation file, in as much as it's permissible or possible, contains both, of course, incriminating material, but also exculpatory material. How do you get exculpatory or material that is exonerating if you don't require the suspect to record a statement? If a suspect is going to record a statement, I want to ask them, I mean, there's no replacement for honesty. You see, the Constitution binds the DPP to make his decision in good faith.
Yes.
Article 157, Article 10.
He's bound by that.
Why they conferred the exclusive mandate to make the decision to charge and to undertake the proceedings is also required to act in good faith. And we must, at the first instance, presume, and the law requires it, that we must presume that the DPP is acting in good faith.
Good faith,
How does the DPP complete his review if the suspect statement is not there? How does the suspect help the DPP reach an honest, defensible position to charge you if you are withholding the information? I think that is where the transformation really is, the gap really lies.
Yes.
How does a person, and I would advise the public if you are arrested and you've been arraigned in court and a decision to charge is going to be made during the investigation, try as much as possible. Don't you say no one is to accuse himself except before the law?
Yes.
And you're not required to help the prosecution advance their case, but you have a corresponding obligation to prefer an honest statement,
Yes.
because it can help, it can make things easier for you and the DPP.
And because, as Tomika, you'll speak to this, and because it is the responsibility of the prosecutor to prove their case beyond reasonable doubt.
Yeah.
And beyond reasonable doubt, if you only have one side of the story, then you disadvantage.
Yeah.
Yes, but then also, once you are given an honest statement, the investigating officers must also do better to make sure that all the facts, I see a lot of files being referred, and it's in the public domain. You go to court, the prosecution will say, we are not registering these charges because they have requested the investigating officer to complete or to cover some areas.
Yeah.
And you see precedents, the DPP stating that yes, a file was forwarded to me, I returned it so that certain critical aspects be covered. Because when that decision is made, the public will hold the DPP accountable
Yes.
for that decision.
Yes.
You must be sure, if you want to hold the DPP accountable, there are two ways of doing it. If you believe that the decision to charge, despite everything, was still made in error, because you see, it's a decision which infers some discretion. Sometimes it does, even judges, there is no need for appeal if judges can't make honest mistakes.
Yeah.
So sometimes even the DPP, acting in good faith, may make an honest mistake. And the way to go about it, the opportunity like that, and this guidelines provide for mechanism for continuous review of the cases.
Right.
They can review them on their own motion, but you can also trigger the review by writing. I mean, if Kenyans want to see the good thing, they can see the good things. But if you want to be stranded on a line, it's stranded.
Yeah.
You can apply for review.
Yeah.
And I think let us also not be suspicious when the DPP, because even when the DPP reviews this decision to charge, it benefits the public. Because we already said it acts in the public interest. If we see charges registered and then a review is made and charges terminated, instead of celebrating that the DPP is animating,
Yes.
we become suspicious and wonder was it
Why, what,
there's
yeah.
hand dealings.
Yes.
I think that is the kind of suspicion that doesn't inspire confidence. And you see, but then okay, fine, there is a constitution underpinning. I was about to say, we can do without this, but there's a constitution underpinning for this kind of conversation.
Yeah.
Look at Article 10, public participation and all that. DPP is trying to do his best. Nobody has gone to court to extract an order to require the ODPP to run this cafe.
No.
But they're thinking that we connect.
Yeah. The public. And it's a good thing.
So we must first of all recognize the transformation that is going on, ask ourselves as an accused, as a suspect. And I already said in my opening remarks that there's a majority of Kenyans who come into contact with the criminal justice for the first time.
Yes.
They have never been inside court. They don't know what it means to be arrested. They don't know about pretrial detention. They don't know about bail,
Yeah.
about bond, about surety. Yet you've been running this that you told us off the cuff before we started that this is like the seventh,
The ninth one. Yes. Yeah.
and you've covered a lot of areas, including bail.
Yes.
That has started. Now today they are telling the public, should you come into contact with the criminal justice system, do not be afraid. Do not hold back information that can lead to a decision that excludes you from the criminal justice system.
And
Anita,
Anita, let me just add something. One of the benefits of the decision to charge is that we are insisting on the rights of the victim also. Because when you're making the decision to charge, you also ask yourself, is there anything that you can salvage to mitigate the position of the victim? And therefore, prosecutors are required to apply ancillary orders to investigate and trace proceeds of crime so that the suspects do not benefit from crime.
Yeah.
So you find that as you make the decision to charge, there are alternatives to prosecution, that is plea bargaining, sometimes with a view to restituting to the victim what was stolen from them or what they did, what they lost during the commission of crime. And I think it is very important for victims to realize that internationally they become active participants in the criminal justice system, and just being by active participants, not just to make sure that the person is convicted, but also to make sure that whatever we can recover and restore, asset forfeiture and confiscation, is done as quickly as possible and at the earliest opportunity.
Yeah. Yes, Tamika.
And I think it's also really important to acknowledge that the prosecutors, you're not making these decisions in a vacuum. they're getting information from the investigators. And so when that decision is being made that there's additional information that's needed, it's that cooperation
Yeah.
with the investigators
Yeah.
that's so critical, so that the prosecutor can have that open and honest conversation
Yeah.
about this is what we need to prove this case in court.
Yeah.
This are the instructions that we need to give in order to get that evidence. And that's where that sort of prosecution investigator relationship plays such a critical role.
Yeah.
That decision to charge lies with the prosecutor, but that investigator is needed.
It's a whole system.
It's a whole
Yes.
system point of view, so
Yeah.
that when the ODPP brings a case to court, that the
And that's
judge who
important
gets it is
discussion,
gonna know this case is ready to go.
Yeah.
Yeah.
With this full team working hand in hand
Yes.
with one another.
Yes.
And I think that the guidelines really do speak
Yes.
to
And
that.
before we get to the guidelines, I just want you to take us through the criminal justice system. There's always this, we don't know who does what.
Okay.
You know, so when a case goes out, I know actually everything, the backstop of the DPP. Like anything, just take us through that.
So let me describe it as a pipeline.
Yes.
I'll start with the pipeline model
Yeah.
because we use it to describe. You see a pipe like this, something is coming in, something is coming out. So
Yeah.
your pipe which has water, as you're walking through a building and someone is washing, and then the pipe has holes, and then the places where water spills on you,
Yeah.
keep that in mind as the criminal justice system. So what comes in is forms of injustice, some form of violence, some
Yeah.
form of violence within the community that amounts to an offense. So I remember SPP was trying to describe actus reus and mens rea. So let me explain it using Steve's water.
Yes.
So Steve has a bottle of water. I take his water.
Yeah.
That is the act,
Yes.
the criminal act.
Yes.
I take his water with the intent to permanently deprive him of it. That is my intention.
Yes.
This is the guilty mind.
Yeah.
That amounts, this is an act I have done here. That amounts to an offense of theft. So then Steve will go to a police and say, my water was stolen. A police officer will investigate. The investigation process is the starting point. So they investigate and verify that he did have water. He had water where he said the water was. The water was taken, and he identifies me
As the
as the
person
person to the exclusion of all others
Yeah.
who took that water. That's the investigation process. Once that investigation is complete and the investigator is
And the
satisfied.
agency specific to this role.
Yes, and it's the first step of the pipeline.
Yes.
Once the investigator is satisfied, I have concluded Steve owned water, Steve's water was taken. Steve's water was taken by Wamaida. She intended to never return it to him. He will write that down and take it to a prosecutor. So he has then completed his investigation. That file is brought to a prosecutor. Now, with the decision to charge, the prosecutor must assess everything in the file
Yeah.
to address two things. Is there sufficient evidence?
I will let Mule speak to that. And speak of the system.
The sufficiently come in, I won't stop.
Yeah.
I'll just give to the example of
Yeah.
this case. So the sufficiency of the evidence is tied to how the law has described that particular offense.
Yeah.
So you're hitting the ingredients and then what the evidence law requires. That I have information that is relevant, admissible. Let's say Monica had recorded a statement, and she only talked about our presence in the room, but she hasn't said anything about the water.
Yeah.
That is not relevant.
Yeah.
It does not need
Okay.
to come into. So that's what a prosecutor is looking at. What has been put in this file, that do all of them check through? And the guidelines have listed out all these things. This is key evidence. Then the prosecutor is satisfied that there is sufficient evidence, and then is satisfied that this offense is in the public interest to prosecute. That I am not wasting public resources.
Yeah.
However, it is in the good of the wider administration of justice. Not because, for instance, Steve went on Twitter and said my water was stolen. That is public outcry, not public interest.
Correct. We'll talk to that.
Public interest
Yeah.
in the wider administration of
Yeah.
justice. It serves the criminal justice system that
Yeah.
will prosecute this matter. So as a prosecutor, they make a decision and say, I will charge this person, please arrest Wamaida. We are now moving into the chain of prosecution.
Yes.
Because then a decision to charge has been made.
made.
But the decision to charge is a continuous decision.
Okay.
Yes.
Tomorrow when we appear in court, as a prosecutor, I'm deciding to continue a prosecution. Every day the case appears in court, I am making a decision
Continuous.
to continue.
Okay.
Because if something happens along the way, for instance, Wamaida says to Steve, I'll give you back your water.
Yeah.
Let's stop this fight. So
Yeah,
then
yeah.
a prosecutor should take these new emerging circumstances
Yeah.
and then make a decision either not to prosecute on the basis of an agreement, on a basis of payment, on the basis of, and there is, and then Steve and his people like to stop that. This is why setting up guidelines for the prosecution office is critical, because the office is saying, despite what the environment is, including mischievous lawyers, despite that environment, as a prosecution office, we want to be held accountable to this.
Yes.
That every person you have seen coming to court, we have made a conscious, they didn't wake up and fall in court.
Yeah.
I have made a conscious
Conscious
decision as a prosecutor. I've made a decision that irrespective of whether it was done here in Nairobi, was done in Eldoret, was done in Mombasa, is consistently done. It is not done on the whims of an individual. It's not done to punish a certain person, but I can look at it and know it was consistently done. And part of how you know it's consistently done is you develop how the decision is made in terms of the instruction around it, but also where. And so the guidelines create forms. So that all I need to do is not just randomly believe what was on someone's mind, but someone has put their mind on paper. There is a form that indicates I have reviewed this evidence, I am satisfied.
What if I'm not satisfied, or am I either?
So the making of the decision to charge is the institution of prosecution and determination of prosecution. So if you're not satisfied with, as a prosecutor, what you have received as evidence.
Yes.
And this was actually part of where the greatest conflict came between prosecutors and investigators. When a prosecutor says they're not satisfied, they give back the file to the investigator.
Yeah.
But the feedback, for instance, we got during the study was investigators are saying, the file is being rejected, but I'm not being told why. But you see, when you have guidelines that explain to you why, and you also have required a prosecutor to say why, so you're not giving an investigator a file, and it would appear as really disrespect, but you're saying, go build up on these 3 lines of inquiry that still did not have enough information on this particular thing.
But Omaida also, even before we filed the case in court, I think maybe Tomiko, Steve can speak about the decision to charge also provides for alternatives to trial and alternatives to prosecution and how we treat the vulnerable in the society. And people are not looking at that because now we have the diversion policy, we have the plea bargaining. Steve, I do not know how but in the decision to charge, you know, when you're making you might not make when you're making the decision to charge, you will decide either to go to trial, you can divert, you can
alternative
to trial or alternative to prosecution, which I think defense counsel sometimes misunderstand.
Maybe in another session, we need to have a focus on the defense trial, the defense attorney. Because sometimes, I say this,
we should,
I appear in those courts, and I see sometimes they are sabotaging the interests of their clients. You see, I already assume that we have covered in the series a discussion on the diversion.
Yes, we have, yes.
And plea bargaining. Yes. I think this is what I can say in terms of animating courtroom experience, and those who are watching should take note here. Usually the procedure is, after you've taken plea, ordinarily you ask for reasonable bail terms, which most of the times the prosecution never opposes. And you also ask to be supplied with documentary evidence with the prosecution counsel intends to rely on. The standard. But I think now, I want to ask the public, raise your hand so that you can confer with your lawyer or at least ask permission to address the court directly. Say, can I speak? In this particular case, although I've taken plea, or even before I take plea, I have not recorded my statement. Am I going to get an opportunity to record a statement? Or although I recorded a statement, do I have an opportunity to review that statement? Or I have something significant? So always keep on conferring with the lawyer and bring the attention of the court. Because then you can alert. Sometimes, you see, what happens in court is this. You may have something you want to communicate to the prosecution counsel. But then your lawyer is there and lawyer is not taking the cue. But once your case has been mentioned, you see the prosecution counsel has so many files on the table. They call this file, you move the doc, the court deals with it, another file is called, then you leave. Most of the time, accused persons don't sit back to wait for the prosecution counsel. And even if they do, the prosecution counsel, I hope senior counsel, you can encourage all of them not to be afraid to come into contact with the accused persons. Because sometimes in the corridors, they're a bit cautious.
In fact, in the decision to charge, there is a whole paragraph of how a prosecutor should treat a suspect or an accused person that is unrepresented.
Yes.
Because you are the custodian of the process.
Yeah.
And you must make sure that it is fair.
They are cautious and say, no, if I'm seen with this accused person, probably I'll be accused of taking money. No, I think for this decision to charge to be animated and for us to extract the full benefit that it has, there must be some communication channels that remain open.
Yeah.
And if the defense attorney is trying to block that, I want to encourage accused person to go directly
Be bold.
to the prosecution counsel or just raise your hand.
Because it's a
There's the
lie.
uncertain part.
Yeah.
Legal fees, yeah?
Yeah.
Extract my fee as a defense counsel.
Yeah.
Sometimes terminating the case will affect my income.
It will.
As the
Definitely.
case lawyer.
Yeah.
And I don't know if I terminate, if I request that the prosecution terminate this case, how will I get my fees?
But I think I asked that question here at some point. So what happens to defense lawyers, for example, when you go to alternative ways of settling
The
a case?
idea is not to put money first,
Yeah.
lawyers will innovate and find other ways. Personally, my experience is this. If a case is fit for diversion,
Yeah.
I will allow the prosecution counsel.
That's good.
Because it's permitted under the law.
Yeah.
It is permitted. If a case is fit for plea bargaining,
Yes.
I would allow the prosecution counsel that my plan plea bargaining.
Yeah.
Which means admit to an offense, and then the prosecution exercise the discretion can know what to do.
Yeah.
Whatever the circumstances, if there's some new evidence that the might have spoke to it, I will always allow, then fees will come later.
Okay.
I can't sabotage it. Because I want all prosecution counsels to also be alert.
Yes.
Be alert, and as we all know, you keep on evaluating. Sometimes evaluation means also look at the demeanor of the accused person. Sometimes you put someone on the door and they genuinely look surprised that they're in court.
Yeah.
If they're trying to relate to this offense, they can't. I think it can trigger some review. I know ordinarily, because they handle many files in court, it's not humanly possible to always go back with the same, because you go back to your desk, there are new files to review because they have to be in court the next day. But I hope that they get to find time to look at the demeanor of the people. Look at this.
In short, I want us to complete the system, the criminal justice system, and then quickly, Mule, if you could just take us through what you look at when you make the decision to charge.
Okay.
Then we have to go social, so make it quick and short.
Okay.
So first, I must say something to what Steve is giving as advice to prosecutors. That has also been prescribed in the guidelines.
Yeah.
It is a sixth consideration when you're taking the evidential test.
Yes.
In every file a prosecutor is making a decision on, the accused statement must be present.
Yeah.
So you're not coming into court blind, so that the day the accused finally speaks, they say, actually, I have a twin brother. It was him
Yeah.
there.
I have that question. The element of surprise is lost, is it? When you have everything on the table. So what do you play?
No, actually, there's a lot, because the element of surprise, what you reduce is the element of crisis. But surprise happens in every human interaction.
Yeah.
Even as someone has recorded a statement, how they recall it 2 years later
It's
and
different.
they are presenting it is very different. One thing which they did not think was significant can pop up in court, and it swings your case to these facts describe a different offense or a twist to the offense that requires you to then review what you charge this person for.
Yeah.
So there will always be
surprise.
It really is sometimes like the legal drama. So you asked me to complete
the system.
So once the prosecutor has made a decision, and I said it's a continuing decision, they then prosecute that case. When they have completed their case and the defense has gotten an opportunity to respond to what has been raised to accuse them, and in this case, Biojaman Kamani is their process.
Yes.
Umalize, uendelee, and then the court may
go to court.
a determination. So
Yeah.
the court then takes what has been presented to it.
So the court can also just say it is the evidence you provided, in as much as you thought it was okay. The court has the discretion to say it was not enough.
So theirs is not even discretion, it is their standard.
Oh,
so as
okay.
a prosecutor, the standard you have when making the decision to charge is a reasonable prospect of conviction. That reasonable, all these things I have,
into account.
if I place them before the court,
Yes.
then reasonably the court will agree to convict. But then you go to court and something happens.
Yeah.
Witnesses don't show up.
Yeah.
An IO is transferred. So
Yeah.
you have a separate IO who perhaps does not discharge with the taking of the
IO is
testimony, investigating officer.
Investigating officer.
So that person maybe does not discharge with delivering the testimony in the way that you would have liked.
Yeah.
So what the court hears is not always what's in the file, because humans then say to the court what their experiences were, not just what was written.
Yeah.
And the people
Courts can
interpret
also
it.
call evidence.
Yes.
If they find there is something important that
okay.
has maybe.
If the court can call evidence, the court can also, as it continues to hear, suspect that this amounts to a different offense, and even give indication in that direction and move some of the matters in that direction. Sometimes they can also ask whether the parties would like to resolve this outside of, because the nature of the offense would actually be resolved outside of
the court.
the full trial process. But then the court puts its mind to the facts that have been placed
Presented.
before it
Yeah.
by the prosecution representing the state as the people with sole state powers of prosecution, which is the DPP and whoever he has delegated in court. And the accused person responding
Why
to
are you
that.
looking at Steve?
Yeah. And it is part of the criminal justice process. They must have their representation.
Okay.
It's actually, I think, even the countries and the criminal justice system is progressively working towards to make sure there's legal representation. So the court puts its minds to the facts and then makes a determination, which is a judgment. It says umepatikana na makosa.
Iwe funzo kwako na wengine.
So umepatikana na makosa is we have convicted you by law. And when you are told, cry for yourself.
Jililie sasa.
Yes, your mitigation, and after you mitigate, and you know, that's why now everyone is from your job. Come on, you can keep quiet, you can come across, you can go and so on. And so once you give that, the court then sentences you, determines what the penalty, as the prescription of the law, and their own sentencing guidelines based on whether you're a first-time offender, second-time offender, the impact of that particular offense to the victim and also to the community. They make a decision and they give you your 10 years, your 20 years, your life,
Whatever it
based
is
on
you're
whether they have
getting.
discretion. So that's the criminal justice system.
So it's very important to note, I think, to the public that the DPP doesn't operate in a vacuum. It's a whole pipeline.
And actually the benefit in sharing the process to the other actors in the criminal justice system is saying that I recognize as the Office of the Director of Public Prosecution that the work or the mandate I have been given by the people and the Republic is a very intrusive one. Someone seated here, senior counsel can be seated here, get a file in my name and say, go arrest her. Someone will come to my house, they don't need to knock, they come in, take me in whatever means, lock me up and detain me.
Block your bank account.
Without telling me, or block your bank account, put me in the press, affect my reputation. That decision is very intrusive. It is actually the interference, it's where state power and individual rights come into contact at any given point. And so the person who makes that decision, we must be very careful to make sure we know how they make that decision, we know who has the power to make that decision, how they make it, and how they are holding each other accountable.
So quickly, Mule, you must tell us what you look at.
Let me start by saying, continuing from the pipe.
Yes.
And the making of the decision to charge is part of the process in the pipe.
Yes.
So we start from a situation whereby an investigating officer takes a police file or an investigation file to a prosecutor. Now, a police file has got 10 sub-files, marked sub-file A to J.
Okay.
Let me not go to the 10 sub-files. No, there are 10 sub-files, and all of them are very important. So the prosecutor gets the file and considers what you have now heard. Is there a prosecutable case with a realistic prospect of a conviction by a court of law? So that the prosecutor, to determine this question,
and a court of law properly guided.
A court of law properly guided.
Okay.
So what is a realistic prospect of a conviction? The prosecutor will consider whether a court of law, properly constituted, applying the law, taking into account all the evidence and all the circumstances, will return a verdict of guilty. Now, how does a court return a verdict of guilty? The court receives evidence beyond reasonable doubt.
Okay.
How does the prosecutor establish evidence beyond reasonable doubt? By proving all the essential ingredients of the offense for which the accused person has been charged in court. At that stage, the prosecutor applies what now you have had as the two tests. And the first test, very critical one, which is objective, and the prosecutor may not have a lot of discretion, is the evidential test.
Yeah.
And there are 6 conditions which the prosecutor looks at. For the sake of time, let me
Yeah,
mention.
please.
Is the evidence available? Do you have it? Let's say, do you have witnesses? Are they out of the country? Perishable exhibits, let's say like wildlife, meat, dealing with, are they paid? Are they gone?
Yeah.
Is it available? It's a consideration. Shall we have the evidence? Because the court will require exhibits. Admissibility. Is the evidence admissible? Let me give an example of confessions. People confess, but there are confession rules which guide investigators on how to obtain a confession.
Admissible means what? Is it acceptable?
Acceptable.
Okay.
Yeah. So if a confession was not obtained properly in accordance with the confession rule, it is not admissible. The prosecutor will say.
So you can't come and record me in secret and use it against me.
No.
I must know.
You saw recently about a gentleman who recorded the wife. Got the evidence from the wife, and the court said it was illegally obtained, and
There are rules.
last week.
Yeah.
Then you go to relevant. Is the evidence relevant? Does it establish the essential ingredients?
Yeah.
Then you go to reliability. Reliability, we are talking about trustworthy witnesses. Is this a victim who has come to court just to settle scores out of the data or something?
Yeah.
And then credible. Is it a witness who has lied before court before? And then the last one is the strength of rebuttal evidence.
What is rebuttal?
This is where we are talking about the explanation which the suspect gives. And we must get a statement under inquiry, or a normal statement, or a cautionary statement from the suspect, so that we know his explanation. Why did he commit this? And what is the basis of this? The basis of this is provided for under the penal code: criminal responsibility, criminal liability. And there are some circumstances which can make, this is a suspect, he committed an offense, but he can be exempted. I'll give you just one example. Mistake of fact.
Yeah.
We are here, we all have mobile phones. When we are leaving, I pick your mobile phone. I go out, maybe even several kilometers. Have I stolen that phone? No, it was a mistake of fact. I thought it was mine.
Okay.
I hope you understand that.
Yes.
So now, these are the 6 circumstances: available, admissible, relevant, reliable, credible, and the strength of rebuttal evidence. That is the explanation by the suspect. If the file does not establish or satisfy these tests, the prosecutor rests his tools. The file is closed.
And maybe just to add on to that, and maybe can speak to this, there are 2 things that can affect the evidential test, even though you have sufficient evidence, according to the offense you are considering. Issues of the process, which can lead to judicial review. Looking at the process, the way all these things were done, can affect you are deciding on the evidential test. And also issues of human rights, the way somebody is treated from the although you can have sufficient evidence, but these are some of the things that can affect you are determining whether or not you have sufficient evidence, because it would have been affected or tainted by the process that was used, or by how human rights were.
So if the file satisfied the evidential test, it will go to court. But still, we also consider the public interest test. And the basis of the public interest test is the Constitution, Article 157, Sub-Article 11.
No, wait. That is not what is trending, is not public interest. Public interest is not what is of interest to the public. Oh, so what is it? What is public interest?
Right now, let me give an example. Wamaida has knocked somebody, and the public is out there with a car.
Yes.
The public is out there paying for
Yeah.
We will not consider that. Is what interests the public. That is public interest. That is what is interesting to the public.
Okay,
but it's interesting to them.
Or public interest is really, it's not tangible.
Yeah.
You can't explain it, because it is also the interest of the accused. It is something that accrues for everybody who is involved, the whole, even internationally. It accrues. You cannot say this is public interest.
Yeah.
And the best example is environmental cases. When we talk about pollution, we talk about cutting trees. Look at the wider public interest. Can you really say this is the interest? It is something that accrues to everybody. For example, fighting corruption so that we can have sufficient money, so that we can deal with healthcare, housing, education. It is something that accrues, and it is in the interest of everybody, including the accused.
I think from a public eye, from a layman's perspective, when you tell me public interest, I'm assuming it's the noise I make on Twitter.
No.
It's the noise you make on the streets that is public interest. But clearly,
In fact, the noise might actually not be public interest.
To make it simple in the way I put it, it is not what is interesting.
Yes.
Or what it affects the victim, the suspect, and the community.
Yeah.
With respect to
Even animals.
Yeah.
Isn't it? None.
The suspect age, we consider the age.
Okay.
Consider like a minor, a person of under 18 years. Is it in public interest to prosecute him, more likely get a jail sentence, and maybe for the rest of his life, we have spoiled his life. We could as well reform this person. Again, the victim, we also consider the harm, what harm or impact to this victim. To the public, we consider what is the
Right
public.
now it's COVID. COVID fund.
The better is
Victor, you know that we have created laws around things that were sanctified, for example, within families. Like, for example, now you know there can be rape within a family, where your father can rape your mother, and it can become a criminal offense. Now, we look at it in the wider picture sometimes. Is it in the public interest that you have to prosecute this father? Because maybe who will be the witness?
Yeah.
Sometimes it could be the children. Now, the wider public interest would dictate that you look at the sanctity of the family and how families are treated. And if you propel these kind of offenses, what kind of institutions will you create? Yeah.
Okay.
Yeah, so we also look at whether prosecution is the best sanction.
Yeah.
Is it the cost? We are bringing witnesses. Could we divert this case? Could we just restitute, give a warning? You understand? And then lastly, we also look at whether there are interests to be protected. Like that could be an ongoing investigation. If you do a prosecution, you know it's a public trial, you disclose information you would wish to keep confidential. You would also wish maybe not to malign international relations or something like that. So those are the two main tests, evidential test, but I say the most important, if it doesn't pass the evidential test, which is objective and provided for under the law,
It doesn't go.
You are told.
Okay.
I think I wanted to ask something.
Yeah.
The three things you don't do as a suspect or even as the defense lawyer. The first thing you don't do is to doubt the intention or the decision to charge your client or to charge you. You must always know that they did absolutely. It has infinite benefits. The second thing you don't do is to withhold information which can exonerate you if this information was made available to the prosecution counsel. And the third thing you don't do, light a notice to forget the first two. So what this means is, every time I see a charge registered in court, the first to be on the safer side, and if you want to offer competent defense, the first thing you must tell yourself that you're going to jail. I tell my client, first of all, let's start from you're going to jail, and let's show otherwise.
Scenario first.
Yes, you're going to jail. Don't be so casual and reckless in your approach. Say, this is just witch hunt. This is persecution. This is malice. You know,
denial for long.
You know, when you're in denial, you hurt your case more than it can ever benefit you.
Yeah.
I mean, these are people doing their case in public interest, and they've already generated. I already said, nobody went to court to compel the DPP to develop guidelines solution to charge. Nobody went to court to compel the DPP to generate guidelines on diversion and bargaining rules, and to have a public conversation like this. I mean, if it depends on the DPP to be proactive and aggressive in information sharing, they have done so. How then, in that context, Because when you appear in court as an accused person or a suspect or a defense attorney, you must look at the mindset of the prosecution counsel in the broader scheme of things.
Yeah.
This is someone, give my view. DPP can consider that and reject it. Within his mandate, he can do so. Then we just put the trial. But it could be that he honestly missed something, or there was something he did because that if provided to him, for instance, usually, and we do this all the time, I mean, this is sufficient disclosure.
Yeah.
The accused person's statement during the inquiry is usually totally different from the statement given in the advocate's office. Totally different. 9 out of 10. And you see, and you can understand why. And I want you to details you're giving me can actually help you not get prosecuted.
Yeah.
Go and give them the person making the decision to charge you.
Okay, we are short of time. Tomika, just tell me, just a view of the international perspective of all this. I mean, do we act the same globally? Because you're global citizens. Do these things apply? The test?
Oh, absolutely.
Yeah.
So in the US, we are required to go through the same sort of analysis. Do you have sufficient evidence to meet each of the elements of the charges that have been laid out?
Yeah.
And can you prove this case at trial beyond a reasonable doubt? And even in the US, it's not enough to make sure you get the conviction. You need to sustain that conviction. If it goes up on appeal, is it going to be sustained there? So you have to think beyond just the trial itself. And so what the ODPP has done with the decision to charge is absolutely consistent with international best standards. And again, by joining what other countries are doing, you really do protect not just the interest of Kenya, but of all countries who want to have their citizens come here and their businesses invest here. When you ensure that there's fairness, accountability, and transparency in the process, you improve the administration of justice, you secure the rule of law, you increase the confidence in the system, and that in turn shows that Kenya is moving in the right direction. So I think that this has been a great movement.
Yeah, so we have so many comments on YouTube and on Facebook. Is it possible to have the sessions with investigative agencies as well as the judiciary? Clearly. Can we have this session with the judiciary?
Yes. The ODPP has got a very open policy, so we can have them here. They can answer one or two questions, and in the spirit of interagency collaboration, that would be a fantastic.
You don't operate in a vacuum, clearly.
We don't.
Our aim is to make things better, not to complain about what has happened before, differences. Our aim is how do we make everything better now going forward.
Actually, you're right. You know, when we say this show, I want to talk about how bad it was then. So I guess we've progressed very well about talking how good it is now. So Karen Carter says, the honesty from Steve of these is quite good. And then let me see. The bottled water example to demonstrate the decision to charge is very simple and well put that any layman can understand. That's Brian Ayodo. Your water thing was very good to pick up. Thanks, Violet. She says good discussion. Rieka says ongeza volume clearly. Keep talking. Somebody else. People are tuned in. Mary, Irene, Angie. Thank you so much. I think sometimes it's very good for us to recognize so that they know we are in this together, just not talking and downloading information to them.
Please tell them the practitioners are coming next Friday.
Yes. So there's a question on Facebook from someone called Nikki Dread. Why do court proceedings have to be postponed every now and then? Remember, that's cost the system. People don't get it very well. Why can't you let or encourage some cases to be determined by the barazas? Again, alternative, all traditional methods of resolving conflicts.
You know, actually the guidelines that people more than 3 times, the prosecution counsel needs to review. But what is also unspoken is that sometimes adjournments are triggered by the defense lawyer at times, because you know when I think people need to understand this, the mechanics of the mind of a defense lawyer. Once you pay some deposit and I've gone to court and I've taken plea, the next time the case is coming up for mention, I'm probably in another court picking up, I've already received a deposit to another client, taking plea in another court, so yours can wait. So I think there's a bit of I think the law society needs to pick up this conversation. And let's have, can we, because if you're running alone, it will slow down the progress.
Yes.
Yeah.
If you bring here the investigators, you bring the judiciary, and you leave the LSK out, there's need for another session. How can you build collaborative greatness between the ODPP and the LSK so that the clans don't suffer? They're your clans because they're in your court. They are our clans because we represent them. So that we don't inadvertently sabotage them. We don't slow down their adjournments. Really, most of the time, I must confess, there are cases I've participated in where they have not progressed to trial. And the first thing I tell the court is that on this day I was away on this matter. And I'm sorry for that. So we have had 4 adjournments, 2 of them attributable directly to me. And that honest admission not only surprises the prosecution counsel, but helps the court look at you and your client favorably. And the court keeps on asking, as this case progresses, do you want to consider a review, a continuous review? Because I'm not, in short, for every statement you make that accuses the DPP of delay, there's also a corresponding obligation of the defense attorney.
And even the courts.
The court sometimes.
And let me jump on that as well, because then different efforts across the criminal justice system have been put forward to try and resolve this. And this is where the Chief Justice delivered on case management guideline. Because what is, I know the country watched the George Floyd trial recently, and everyone was surprised that something so significant can be taken in 2 weeks and it is resolved. What is how we do the case management at a court level, so that it is not just taking single day trials and come in once every 3 or 4 months, because when that happens, something could have happened on a single day. Someone could be bereaved, someone could be at a training, someone could have gone elsewhere. So also the administrative process of case management for the 3 criminal justice agencies is critical. And the starting point, of course, is the Council on the Administration of Justice, the National Council, where they come together and talk about it. And there have been some very good guidelines that come out of that, and just a more robust approach to implementing them and managing to hold defense counsel to account would assist these cases to go a lot faster.
And I just allow that to that, and maybe even to make out speak a bit. What is the difference between our system and, say, the American system? Because you've mentioned George Floyd, and every time we hear people say, how come his came, completed quickly, life went on? Why are ours still dragging?
Let me first say that I think that the judiciary really is taking steps to address this. And the active case management guidelines, I think a critical component of it, which is also consistent with the U.S. system, is the importance of the pretrial conference. The pretrial conference ensures that everybody's on the same page about when evidence must be turned over, what evidence is going to be admissible at trial, what isn't, and then more importantly, what are those critical dates that we are going to have a date certain for trial. And that to me is what is the difference between the U.S. system and the Kenyan system. When you have a date certain, you know the trial is going to start that date and it's going to continue until it's completed. So there are consecutive hearing dates. So you can bring in an entire case within a week or 2 weeks, depending on the amount of evidence that needs to be presented. But that also, that pretrial conference puts everybody on the same playing field, that these are the rules that we're going to abide by, and that there's going to be consequences if those rules are not abided by.
Okay. Carol asks, is there a mechanism? No, we didn't speak to the to cases being determined by barazas.
AJS?
Yes, there is alternative justice systems, and the Constitution has, I think, under the section of the judiciary, included it, and the judiciary has been making efforts towards that. I think it was even one of the
questions by the judiciary,
because ideally it's the administration of justice. It is not the desire to move into cultural practices, because those are not always governed by principles of natural justice that are key. Because the idea of the justice process is that you would have an orderly society. It is not that you would have one group going against the other. So it's useful to have an independent, objective arbiter in those issues, so that it would also be managed and overseen by the judiciary. There are, however, then what Madam Senior Counsel was talking about earlier, the alternatives to prosecution and the alternatives to trial. Those also ease the burden on the court, that someone can come in and acknowledge quickly and transition out. Because again, the criminal justice system is to resolve and to allow the communities to agree that we reject this conduct, not this person. So if this person can take and be held accountable for their conduct, let them come back into society. Our interest is not to put people to the gates of the city.
Again,
they would never come back.
It's not like
And barazas are not mainstream criminal justice. So once you want to go to barazas, the prosecutor's got nothing to do with it because we don't administer it.
Although in this one, I think we must share the spotlight where it belongs, and that the DPP himself at this office, we can't get in court until a charge has been registered. In terms of Article 157(6), we already said that decision is not shared. So I think one of the lowest hanging fruits that the ODPP can easily harvest is to audit the penal code and all statutes creating offenses and decide to decriminalize some of these offenses.
Yes.
Yeah.
Because if you decriminalize, there are some offenses that obviously punish poverty. There is no chance that I'll be arrested while crossing the street on a mobile phone because I'll be maker. There is no chance I'll be arrested sitting on a flower pot in the CBD. You get?
Yeah.
But that jobless youth was walked all the way from Kayole to Nairobi.
Yeah.
You know, I used to live in Kayole. We live in Kayole and to become the CBD, usually going to Nairobi. Yeah? They tell you town bad in that.
Yes.
And town of nowhere.
Yeah.
When you're a fresh graduate, you're living with a relative.
Yeah.
And the DPP must take into consideration the poverty levels in this country.
Yes.
More than half live on less than $2 a day, which means those more than half of the are susceptible to committing offenses.
Yes.
Some of those offenses can be decriminalized, the petty offenses. The cases will move faster. Again, as you move forward with these guidelines and with the input of all criminal stakeholders, the stakeholders in the CJS system, the community, the arresting officer, because the influence of the DPP over the police office is not, I don't think it's well appreciated. It's immense. Look at Section 35 of the National Police Service Act. What does it say? It says the DPP has the power to direct investigations, and they always do it, return this file. Which means the inversion, DPP can control what comes to his desk. Over time, some of these cases, the investigating officers can say, no, the way I understand the DPP, if I check this file, you will divert it.
And that is very true, Steve, because Mula, you realize that in considering decision to charge, once you have passed the evidential test and you're going to the public interest test, when considering public interest test, actually you have to look at the circumstances. It is subjective. You have to look at the circumstances of the suspects. And some of those things will come up. For example, this person had no alternative, this person is poor, this person could have, because of other, the person committed the offense. There is sufficient evidence, all right, but it is not in the public interest because you looked at the unique circumstances of the suspect and decided that it is not in the public interest.
That's interesting. We talked about people living in the low income areas in Nairobi when you talked about murder and plea bargain and diversion. And there's a lot of, there's need to sensitize them because people are languishing in remands because they didn't know what to do. Or because of poverty, they couldn't afford bail or bond. So there's a lot of discussion that needs to happen in that space. Carol asks, is there a mechanism for Mwananchi to seek review of the decision to charge based on changed circumstances? Does Mwananchi have to wait for the day the case comes to court, or is there a way to reach ODPP to apply for review of the decision to charge?
May, somebody who has been charged may, if he so wishes, communicate with the ODPP immediately. Charges are preferred, and that can be by email. We have our online website. You can communicate through email, or you can even do a letter personally, individually, or through an advocate. And it has happened. We have reviewed so many files. Once we receive such correspondence, we call for the file, we review, and then of course take into consideration the circumstances.
So you don't have to wait to go to court?
You don't have to wait to go to court.
All right.
And we have done it so many
times.
times.
Add to that, but the guidelines also cover that dynamic, because the idea is also to make sure the investigator and the prosecutor are on the same page on what's happening. So there's some guidelines on if the accused person is wanting to speak to you as a prosecutor, as opposed to before where you would have a quick stay away from me approach. I don't want to appear compromised.
Yeah.
There is an indication of, as long as you are both aware of what's happening, or the third party is aware, so that you also protect the independence of the office and you're not accused of having been paid off. So there is a way that it can be tracked, and also that supervisors can be aware that people are reaching out to us and telling us. And it's useful because then you're also knowing which gaps are not being covered at the investigative stage.
Okay. Someone says, Duncan asks, who prefers and drafts charge sheet between the police and the prosecutors?
Mule.
Let's start with the preparing. The investigating officer, that is the police, they prepare a draft. And we are not bound by the draft.
They recommend.
It comes to us, and then we can endorse it or make changes to ensure that it complies or conforms with the legal requirements of a charge sheet, because we have legal requirements of what should be contained in a charge sheet. Okay. So preparation, they prepare a draft. We are not bound by it. We can prepare. There are also circumstances where we prepare the original charge sheet. We sign it, file it in court.
Okay. So Joseph says, with the decision to charge, is there a new charge sheet?
Should be.
There should be. We are gazetting an ODPP, Office of the DPP charge sheet.
Okay. Okay.
It will be gazetted anytime, it will be out anytime.
All right.
Yeah.
So there's someone called Backrift, and he's a top fan. Thanks, Backrift. Apart from murder, where ODPP draws the information sheet, other cases are drafted by police. I don't know that this is a question. Only ODPP endorse the charge sheet. There is a need to employ more professional and integrated them at the station so that they assist in making decisions to charge. I think it's a commendation. A recommendation is making. Yeah. And then John asks,
let me comment on how that is resolved in the guidelines.
Yeah.
So now there is a central intake mechanism. So as opposed to files coming to individual prosecutors at any given point, there is a duty prosecutor. They know that all files will come to a central place. This one person will review them today because they're on duty, and then they get assigned to the people who will go to court. That streamlines that process, as opposed to cases coming and bumping into you in court and you're forced to proceed.
Okay. John asks, when ODPP returns a file to an investigative agency to fill a certain gap, and the investigative agents are not able to fill the gap, is the case closed at that point?
Of course, the file will be resubmitted to us, and we'll subject it to the test, the evidential test and the public interest test.
Yes.
And of course, we will require the investigator to give an explanation why those areas cannot be covered.
Okay.
Yeah.
Gloria says, Steve, mostly defense lawyers will not allow alternatives to prosecution because of the fees.
Lawyers need to move away from that, but this is a shared responsibility between the judicial officer and the ODPP.
Yeah.
Look at that. Office of Director of Public Prosecution. You mean this office only common mandate is to prosecute. So if somebody wants to sabotage your work because he wants to protect his fees, I mean, you must step up and stop it.
Yeah.
So yes, lawyers need to be sensitized how they should not, you are hired to advance and protect the rights of the agent, but not at the expense of legal fees. I mean, as practice keeps on evolving, lawyers will begin to innovate within the challenges and discover how to earn money.
Yeah.
And ODPP has actually started some of that sensitization, including advocates out in the field to learn about diversion and plea agreements. And I think the more that you learn about that process and how it helps your client, to be more open to it.
Okay, so Paul asks, thanks Paul for your question, can ODPP open an office where the investigators can meet them for pre-trial before they prefer charges?
We actually, under the guidelines, pre-trial is mandatory, and not only as defined by the judiciary during case management, but as prosecutors, we hold pre-trial with witnesses. Pre-trial is before you go to court for trial, but we hold pre-charge conferences.
Yes.
Isn't it, Mule?
Yes, yes.
We hold pre-charge conferences with investigating officers so that we can consult on issues.
Yes.
So actually, we meet investigators very often, and the relationship.
So you meet for the pre-charge discussion, then
we meet for pre-trial, and every time we review a case, sometimes it is desirable that you have a conference with the investigating officer.
So maybe, Anita, you guys can clarify. There are different types of pre-trial conferences held at different stages of the trial process. Immediately or before the charges are preferred, you hold a pre-trial conference with the investigator to confirm that the case is ready for plea. You go for plea, you hold another pre-trial conference again with the investigator to confirm that witnesses are available, you have done disclosure.
Yeah.
You hold a third one with the court now to again ascertain that the case is trial ready.
Wow. Okay.
I think that is the point now where defense lawyers also come in.
Yes.
In terms of sharing material that the prosecution tends to rely on during the trial, then the defense lawyer is also entitled to get that from it. Although we always request, that as much as, and the guidelines require so anyway, as much as possible, let all the evidence be on the record.
Yeah.
To the extent possible, and let the accused person, shortly after plea taking, have access to that.
Okay.
So that they can also prepare and see how they want to engage with the process. I think the other issue, as we amplify this conversation on decision to charge, there's the unspoken issue of this plea bargaining. Plea bargaining is part, it may feed into the decision to charge.
Yes.
Not just writing for review so that the charges are terminated. Because I already said, for me, it's safer to assume, I'm looking at these guidelines and the rigorous training that the DPP undertakes for the officers.
Yeah.
Once a charge has been registered, it's safer to assume that there's a prima facie case that, if not responded to, will lead to a conviction. If that assumption is correct, the first reaction is not a review with a view termination. How do I plea bargain?
Yeah.
Because if you're going to be convicted, you'll be convicted whether you admit it in the lawyer's office or whether you go through the full trial.
Yeah.
That can save time.
Okay. Thank you so much. I want to go quickly through the tweets. I mean, time is just going on. This is now for the ODPP. Natera Rashid asked, when are you bringing COVID millionaires to court?
Anita,
Yes.
this is a matter under investigation.
Okay.
Again, let me just say we have to apply the test.
Okay.
And that process is ongoing.
And then, as you can see, there are so many other agencies investigating the
Yes.
same.
Yeah.
And all these reports are brought to the prosecutor so that you can make a decision fed from different angles.
Yeah.
Yeah.
So it is interesting to the public,
Yes.
but it may not
It is-
advise at this point.
It is.
It is in public.
public.
So it is both interesting and in public.
Yes,
Yeah.
it affects the
Okay.
Yeah.
All right. I think we answered the one on the charge sheet. Could we have a similar confirmation regarding the Imperial Bank thieves, depositors who have been tortured beyond imagination and nothing is happening, considering a lot? Also, it's a much older case. So maybe that's an older case that somebody is asking about Imperial Bank.
Imperial Bank, the suspects are in court. It's ongoing. It has then been slowed by the COVID-19 pandemic.
COVID has slowed a lot of things, the processes.
But the case is in court.
Yeah, we saw last week, I think, the case of Monica Kimani, the one for Joey and Jackie Marie,
yes.
that they asked for actual court sessions and not physical ones.
Yeah.
So you can do that.
Steve should also talk to advocates.
Yeah.
Most of them are insisting on physical hearings.
Yeah.
Thereby thwarting our efforts to put our witnesses on the dock.
Yeah.
So maybe Steve now, case by case,
Yeah.
this is,
And I think, again, that is the response. I don't think the DP also needs to be very firm in court.
Yeah.
There's that. This one, you can't even blame the lawyers, because the lawyers have very limited role. The judicial officer, it's your court. The prosecution, it's your case.
Your case.
You know the evidence that is needed, you know the witness that is there. It's not a complex case. Why would the defense counsel insist on physical hearing when the matter can actually progress?
Virtually.
You have to put your feet down if someone is becoming unreasonable.
Yeah.
Because, again, you are the state officers, public officers. If there's a delay,
Yes.
we will be shielded from the blame.
Yeah.
But you can respond.
On the spot, definitely. And Frankie Paul on Twitter asked Jared Otieno, the case that was the fake gold case. 2 years later, the case hasn't even moved to the hearing stage. Parties still attending court for mentions. So this guy brings this obvious public argument that with money, this country, you can have your way around justice. Yet you're the public lawyer. You are our lawyer. What do you say? That you're basically untouchable if you have money.
What people are forgetting is that a prosecutor is part of society.
Yes.
It is the same society that is the accused person. They are the witnesses. They are the complainants. And everybody we need to work together to make sure that
Collect those responsibilities.
Yes,
Yeah. Okay.
And also money plays that significant role. If you have access to more resources, then you can hire 10 lawyers.
Yeah.
And all of them can insist on addressing the court.
Yes.
Obviously, the court gets fatigued. They look at the cost list, mentions the law at 21.
Yeah.
Wow.
Then you have hearings, about 7. Then hearings, continuing hearing. So you look at, you are number 3 on the cost list. This matter, for any example, this where the case person has resources,
Yeah.
you have 10 lawyers on record, and each of them insists on taking 10 minutes to address the court.
That's a lot.
Again,
Yeah.
you can blame the lawyers because the lawyers don't control the process. You blame the judicial officer. And I can only speak as much as you permit me to.
Yes.
If the prosecution client said, no, we have to agree. What is it that the other lawyers want to amplify that can't be said by the lead counsel?
You can remember in the DCJ case, we had 72 lawyers.
Wow. 72.
10 of them senators and members of parliament and senior counsel.
Yes.
So
Yes, I
Steve
remember
is
that.
right. The court must be in a
Yeah.
position to control.
All right, Shari M says such a noble initiative in awareness and creation among the general populace on criminal justice systems. That's a good job. Jane Mwafi, I think you need to work on files being presented in court instead of the many adjournments. Again, there's that, we need to continue educating people about how the system works, that your officers ask for due to absence of police files. Someone called corruption is evil says, you guys are bad jokers, update Kenyans on the progress report on all corruption cases pending in courts. And by the way, have you appealed against the release of Waluke?
Yes, we have.
Yeah.
Great. Yeah. And then we'll have a different session to discuss corruption. So we'll update, we'll keep updating again also on social media how this goes. So on the criminal justice system, the pipeline, somebody says, Solengo Jr. had said too many processes, hata nimepotea njiani, like, but I want to believe he's gotten it right with the analogy of the pipe. And then Samora says, these are one of those tweeters, those people just right. So I think we're incompetent or complicit.
Okay.
Yeah. He's entitled to his.
He's entitled, but you see, we are also a reflection of him.
Oh Lord, okay.
Yeah, because we are the society.
Yeah.
We are a reflection of our country.
him,
and
yeah.
who we are.
And the unadulterated African says, what's happening with the Kemsa heist? No arrest 1 year later. Focus on your core mandate.
But also, I think what we need to do having a balanced and dispassionate view is very important.
Yes.
The law, not the Constitution or ODPP Act. There's no mandatory requirement that the PPP must win all the cases.
Yes.
Actually, that would be a very wicked and evil approach.
Yeah.
Yours is to present your case the best of your ability.
Yeah.
Because it's based on your reading of the law.
Yeah.
If I'm defending a case, I'm defending because based on my reading. As an ethical concern, I feel I shouldn't be defending a case that is indefensible. That's from lawyer to lawyer.
Yeah.
At that stage, then I would negotiate for plea bargaining.
Yes.
But if the DPP is the view that a trial or case with a reasonable chance of success is closed, I believe otherwise. That's why you have a magistrate paid for that one.
Yeah.
So I think the best way to audit the DPP is to look at the judgments. How many of these judgments and rulings that are given that don't succeed actually indict professionalism, the professional and competence of the DPP? Because if the court is saying, I'm not convinced, even the court himself can be that ruling can be overturned. So I think this blanket condemnation and the unnecessary pressure, this is really good,
Yeah.
But the DPP is not doing well in terms of communication on how to manage public pressure.
But Anita, you must also understand that when you're under the decision to charge, after you've considered evidential test, you have passed the evidential test, you're going into the public interest test. One of the things sometimes that can influence your mind is the timing of the prosecution. Sometimes the atmosphere is so polarized that prosecuting at that time will be futile.
Yeah.
So, like for example, we have cases like in Nigeria, when governors were still governors, they could not be prosecuted because of the money they had and the power that they wielded. Sometimes you can defer prosecution so that you do it at a conducive time. I'm not saying that's what you're doing, but that could be one of the considerations in future.
Okay. What if the investigation, Julius asks on Twitter, what if the investigation is done by a private investigator authorized by a private security regulation authority after initial reporting policy? I think he's asking the role of a PI in all this.
It's of legal significance. I think that Justice Nyakundi is rolling in the case of Senate Assembly.
Yeah.
So, most of the time when you have a private investigator to collect evidence, there's a lot of censor there because the very idea, the model of the operation is that they follow you quietly, discreetly, and then they collect information that they won't even use because it's not admissible.
And not even that, that is advancing an individual's interest, not public interest. And you cannot use public resources to advance something that an individual thinks is their interest. You see?
Okay.
I think maybe Senior Counsel should talk about policing powers of investigation because there is interpretation around that. The investigative function has been vested in the police. They are supposed to do that and hand over their investigation to the prosecution. This is the Republic, and the Republic is containing the public. In terms of order. And so those are the vested institutions with investigative powers. Anyone else is then mandated through the manner prescribed by the Constitution and the law. So for instance, KWS investigates, but they have gotten authority, and so they have investigative powers. IPOA have investigative powers. So investigation is not a private function. It is part of public good. It is regulated by the Republic.
Okay. I think there's just another question on private.
But such information can be used by the police to inform their investigation.
Do Kenyan criminal law allow for private criminal prosecution? Is that something like that? What is it? Private criminal prosecution. I'm not satisfied with the decision not to prosecute. Can a private citizen pursue it? I think if I am not satisfied, that's what he meant.
I think, yes, the law allows it, but rarely will you get there. I see some people threatening that you have to apply to the court. That either the DPP can give permission, which rarely happens, or you need to move to court, the court can permit you, which also, I think, that opportunity is there. In the extreme and rarest of circumstances, the DPP refuses blatantly to execute his mandate.
So the answer is actually yes, but you must satisfy the conditions that have been set down by the law. Isn't it?
Yes.
All right, we are winding up. I've seen many, someone says, Lucian Ogano asked, I've seen many adjournments in criminal courts due to the IO. Now I know, investigative, not complementing the prosecution well enough. Is the ODPP in control of that?
What we are doing now, we are using court users committees. Court users committees comprise of all the players in the criminal justice system. We bring along the prosecutor, we bring along the LSK, we bring along the investigators, we bring along the judicial officers, so that there is harmony, there is synergy, and there is working together. And it has worked in very many stations. Because if it is the investigator, why are they not bringing files or witnesses to court? They are able to say these are our challenges, and then they can be discussed together and a solution reached. So we are working on it, and there are some stations. I was in a station this week where there was that problem, and the judge himself said, I have solved this problem of non-availability of police files through court users committee.
But also to complement that, Tomika talked about the central case intake, where now you don't take the files to court, you bring them to a central place in the either at the county level, regional level, or in the headquarters, so that their intake is central. What we are doing, when fully operationalized, we'll be having a duplicate of the police file that we are referring to. So we'll no longer be referring to the investigating officer unless when we need the originals. So we'll be having the files with us so that the issue of the files not being brought will not arise. We are also encouraging forensic and scientific evidence so that we move away from much of oral evidence. It's more credible and it is easier to preserve and to present before court.
Somebody on Facebook, Jeff Kamakil and Athanas Jalego, the ODPP has a public and complaints. You can lodge your complaint. I've seen they put a complaint about land. I was just discussing in the morning about how land is civil until a criminal act is committed. So we're just saying here that maybe for these comments on land and these cases that they don't have resolution to, they can write to the public complaints at odpp.gov.ke. .go.co.ke?
Yes.
That's what, go.ke. Yes, sorry about that. Yes, there's been a lot of questions on Twitter, but again, it's all people not understanding the process, and I think it's a continuous conversation. People not understanding the role and the mandate of the ODPP, and of course, how the criminal justice system works, and of course, the rights of the accused. What do you have any rights, even once you have everything against you? What can be done? So there's a lot of conversation going on, and we intend to do this on this platform.
But tell them they have all the rights under the Constitution, including the ones that are in international instruments, have been incorporated into our Constitution.
Yes, I am going to give you, this is a finally, not an African finally, this is actually finally. Final remarks. Are we making progress?
We are making progress. I can confirm that we are getting more convictions because of the use of the guidelines. They are about 1 year old, but we are getting more convictions.
So it has improved your conviction rate?
And why? Because the prosecutor is confident, and the prosecutor has got all the materials to prove their case beyond reasonable doubt. Because the investigation file passed through a sieving process that is making the decision to charge. There is no guesswork. Their parameters are set. The prosecutor knows them. Secondly, there is public confidence. The public knows, including even the players in the justice system, the investigating agents. They know when I'm going to a prosecutor, this is what I expect. When I send my file, this is what I expect. So they prepare in advance.
Okay, so let me ask you just, I think I'm not running out of questions,
Yes.
but there are 29 court stations in Kenya.
Well, yes.
There are prosecutors in all the stations.
Yes.
Then there are 47 counties.
Yes.
Do they have the authority to make the decision to charge on all cases, or do some of them come here to Nairobi?
No. They have the authority to make decision in all cases, apart from
There's a threshold.
corruption. It's only the DPP who gives consent to prosecute corruption.
There is a guideline. There is a guideline
Yeah.
on the threshold, because it will depend, for example, on the amount of money. It will depend on the status of the person. It will depend on many things.
So it won't be a chicken seller in Nyakachu?
No. There is a threshold, and we have a guideline on that.
Okay.
And also in counterterrorism
Yeah.
cases,
There's
those
a
cases
threshold,
of national interest.
Okay.
You
Like, we
definitely
have specialized units here, so there are cases that must come to the specialized units.
Okay. Tomika, are we making progress from your perspective? Are we finally part of the global, what is it called, movement in access to justice, improving access to justice? Are we good?
Let me say, I think Kenya has always been a part of the global movement, right?
Yeah.
And it's about how to make the criminal justice process more efficient. And I think that the decision to charge guidelines are absolutely going to help in that process. And in particular, the development of the processes that are going to be equivalent in whatever county you're in. You know that the case is going to be reviewed in the same way, it's going to be prosecuted in the same way. And I think that that's obviously going to make things, improve matters here in Kenya, and ensure that the rights of citizens are upheld. So I definitely think that everything is moving in the right direction. And certainly improving the administration of justice has that interest that's not just national, it's international. So absolutely.
Okay. Steve?
I'm going to speak to the challenges because the success.
I wanted to ask you actually, room for improvement. What do you think?
Well, then, let me just, because I know this is my last comment, to appreciate, in all honesty, when you watch this, actually follow this series from this, you just see, the panelists.
Yeah.
You don't, the infrastructure, the personnel, the work that go to project this, just so that the public can be updated,
Yeah.
I think is immense.
Thank you.
What I've seen here is immense, and I really appreciate it. That really is great work going on there.
Thanks.
Some of the challenges that remain unsolved or opportunities for improvement, I have my doubts whether the DPP understands the overarching influence of his mandate on the entire criminal justice system, because if you look at the broad spectrum, the CJS, from the community to the investigator, the police, to his office, to the court, to prisons, to probation and aftercare, back to the community, there's going to be a lot of stress if the DPP buys more than he can chew. So we must learn to disperse some of these functions, because also if it doesn't disperse them, or take an interest. I'm not, his mandate is well defined, yes. But what I'm saying is this. I don't think there should be joy in recording convictions all the time. It goes the other way. It could also mean that Kenya generally is a country that is full of people just lawbreakers, you get? Yeah. Because you're convicting them on the merit. So when there's that joy and you're achieving your mandate to put bad guys behind bars, but you don't congest our prison. Looking at, can you audit your work and tell us what can you do to make sure that the society is gender compliant? There are countries like Sweden, the Scandinavian countries, they're actually decongesting, they're closing prisons because no one is being prosecuted, no one is being convicted. But
That's
here,
paradise, no?
Yeah. So I think there's the mandate, the core mandate, but then there's the extension of that mandate. That the DPP must lead the others, so that we can have a society that has low crime rates, low recidivism rate, which means repeat offenders, and the people that actually get there when they're convicted, all of us will be satisfied that he has done his mandate and the society is much safer.
Yeah, and of course decriminalize some.
Some of those offenses involve the civil society much better, like lawyers much better. Be firm in court, let the magistrates tell them the challenges in face. Because the people that by law, the people that are held accountable are public officers. The law tends to push on private actors or private practitioners, even if you are part of the problem.
Yes.
So you must take charge.
Thank you. Omaida.
Final words.
Yes, are we there yet?
Are we there yet? I think we're getting there. Society has changed, crime has changed, people have evolved, and with that kind of evolution, even the criminal justice system must respond to it.
Yeah.
Before, the greatest threat was money would be stolen from my purse. Then there was the people who send me a message and say, Rudisha M-Pesa. Then it has been withdrawn from my account. All those are showing the sophistication in crime.
Yeah.
The change in how people view what they're entitled to, or how far they will go to get what they want in terms of legal deeds.
Yeah.
So much so then that the criminal justice system must respond to that. So in terms of responding to that, this is very necessary. In terms of coming and telling the public the nature in which you have responded, this is an effort in making sure that you don't criminalize poverty. Steve talked about it before, because the ones who are most vulnerable as the quickest way to respond to crime is those who are living at levels of poverty where they do not understand the system, they do not understand why they are under attack, and people in power can actually reach out and make sure these people pay for things they didn't themselves do. So where we have, I think, to go now is move closer to that stage, where people feel that they live within the protection of the law.
Yes.
That because I do not have economic means, I am not vulnerable to being a victim of the criminal justice system. And Steve gave an interesting analogy of sitting on a pot in town. But that should not be, the greatest risk in my life. That I can come on an ordinary day.
I need to feel safe.
I can lose my liberty. I am not sure why. And I only hear charges when we have gotten to court. So this is an extension to the public campaign. We want to make sure that everyone lives within the protection of the law. So in that regard, it is a good step forward. There is still a lot more to be done to protect the more vulnerable, because now it has addressed the more complex.
Yeah. So you have a mic, madam. You don't need that. So I was reading, I think, an article someone wrote and said, actually, trust in government has gone down, especially government services and ODPs at government office. And someone was arguing we need to renegotiate the social contract we have with the government.
Yes.
I think we gave them too much.
Yes.
But now we are saying you're the public defender.
Yes.
Why should we trust you? How do we continue this relationship with this, and especially with such guidelines?
What people should realize is that the purpose of the criminal justice system is to make sure that we have a safe society, our properties are safe, and we are safe.
Yes.
Secondly, what people should realize that prosecution is like postmortem. Everything has happened. We come at the tail end of the activity, and we are supposed to punish the person who committed the offense. As much as we are trying to put the bad people behind bars, there is a need for all of us as a society to make sure that we prevent offenses from occurring.
Yes.
And therefore, the kind of punishment that are meted by judiciary must respond to the need to prevent crimes. And for that reason, you realize that the Office of the Director of Public Prosecution is now putting a lot of effort in asset forfeiture and confiscation, because when you know that if I commit an economic crime, I will lose most of my property, then it censures me not to commit an offense. So we are going beyond the original intention of punishing people that they just have to go and stay in prison. We are taking over their assets, and I think that has increased the faith that people have in the Office of the Director of Public Prosecutions. Secondly, we are taking in a lot of pupils. For example, now we have taken 100 pupils and interns. They learn what we are doing, and we hope that when they go back to society, they'll blend into the objective of the Office of the DPP to make the society better. They'll always, prosecutor might be called upon all of a sudden that a Kenyan has committed that kind of offense in another country, and you're supposed to react. So instead of taking this person to court, you're still looking at, do I have sufficient laws? Do I have police prosecutors who are capacitated? And for that reason, I think we are on the right track, and with the Prosecution Training Institute, we'll not only train the prosecutors and the law enforcement agencies, but even the public, so that we work together, because at the end of the day, it is a shared responsibility.
Yeah. All right. Thank you so much. I don't know whether it is prudent for me to end this without saying we have a nominee for the Chief Justice who's a woman. The present is female. It's no longer the future, it's the present. I even saw Joe Biden saying he's addressing Madam Vice President and Madam, I think, Speaker. And it was, I think, also a first for them. So the present is female. So let's run. We break the ceilings and move on the sticky floors. Yeah.
Thank you so much.
Thank you so much. It's been quite a chat and a good one. I hope you got something from it. At least I did. But you can always go back to the video and just listen to what some views that have been made by the strong panel of experts. You see what it means for the decision of the decision to charge, what it means to you as a citizen, and what happens when you have, it doesn't have to happen to you. It can actually happen to somebody else, and you'll be in a position to advise them. Like you say, when you know, then you're empowered. So thank you once again. Thank you for engaging with us on Facebook, on Twitter, and on YouTube. We will try and respond to the questions you have. We've tried to address some. I can't mention everyone. I can't pull up a Tanisho on this show, so I can't mention all of you, but I'm grateful for you joining us. We look forward to seeing you again next week. I wish you a good weekend and a blessed week ahead. See you again next week, Friday.